Good morning. This is Bernard Nomberg, Nomberg Law Firm, downtown Birmingham, with another of our Tuesday morning sessions on the law. Typically, or usually, it's about workers' compensation matters, Social Security disability, personal injury claims. We appreciate you guys spending a few minutes with us talking about the law. We always welcome your input, your questions, and comments. Today we're going to talk about a topic that comes up in almost every workers' compensation claim at some point or another, and usually it's two different times. It's the return to work issues that face injured workers when they're trying to get back into the workplace. And that usually occurs in two different scenarios. The first time it occurs is after they've been injured and the doctor has made a decision, the authorized treating doctor has made a decision that the injured worker can now, in some capacity, return back to work, whether it's for the current employer or in the situation where they're no longer employed with the same company with a new employment. The issue that we have to deal with in that scenario is, are there any restrictions or limitations at this point while they're being treated? I'll give you a real case example. A labor-intensive job, someone injures their back. They have not had surgery, but they've had physical therapy and medicine. And the doctor feels that the injured worker can return to work, but in this scenario, they just can't go back full-time or full duty, with all the limitations, without limitations or restrictions. So they've got a weightlifting restriction, and the employer has to decide, can we accommodate these restrictions? If they can, then the injured worker has the obligation to make an attempt to go back to work within those restrictions. If they don't, they could be subject to being terminated. On the other hand, if the employer can't accommodate these restrictions, they don't have to make up a job or a job title, even if it's temporary, for the injured worker. In that scenario, the injured worker, in theory, stays home, doesn't go back to work, and the weekly compensation benefits should continue to be paid. The other scenario that we commonly look at about returning back to work is at the end of the healing process, when the authorized treating doctor has put the injured worker at maximum medical improvement. And that's a term that's very commonly used in work comp cases. That's the authorized doctor's way of saying, from a medical standpoint, there's not anything else to fix, to be done at this point. The injured worker has plateaued in their recovery. They're as good as they're going to be from a healing standpoint. What it doesn't mean, maximum medical improvement, is that the injured worker is necessarily 100% healed. It's just the doctor's way of saying they're as healed as they're going to be. And at that point, depending on the type of injury, if it's a body as a whole type injury, the doctor will likely put them through a functional capacities evaluation, and that's a physical set of tests that determine what the injured worker in theory could do at over a 40-hour work week from a limitations and abilities standpoint. Then the doctor gets the report back, goes over it hopefully with the injured worker, but most of the time they don't. And they either sign off on it in that they agree with the restrictions, limitations, and impairment rating, or the doctor gives his or her input and tweaks the report just a little bit. And anyway, that report then becomes very important to the injured worker when trying to return back into the workforce. If they're still working with the same employer, they take that paperwork and they go sit down, hopefully with either their supervisor or HR department or whoever it may be who's in charge, to figure out if the employee can return back to the workplace and in what capacity, whether it's their old job or if there's a modified job that meets the requirements of the doctor's imposed restrictions and limitations. And that doesn't always work that way, in that the employer does not have to make a permanent or even a part-time accommodation in the way the law operates, because we're an at-will employment state. An employee can be lawfully relieved or terminated from their employment if they can't meet the requirements. The problem becomes in the eyes and becomes a stress in the eyes of the injured worker is they've been out of work for quite a while. They're only getting work comp benefits up until they reach MMI, and by law those benefits, weekly benefits, stop. So there's no income coming in until they can go back into the workforce, whether it's for the old former employer, or they have to go find a new job. And it becomes very stressful for the injured worker during this time period in an already stressful environment and time. But there's no requirements or laws that make the employer take the injured worker back into the workplace if they can't accommodate them. They don't have to hold the job open. There's just not a lot of rights, unfortunately, that the injured worker carries right there. However, there are several laws that can be impacted if we feel, after looking at the situation with the injured worker, where laws could be broken. The FMLA, Family Medical Leave, the ADA, the Americans with Disabilities Act, several others that come into mind. There could be EEOC claims that are issues. If the injured worker gets terminated, we always look to see if there's a state claim for retaliatory discharge for terminating the employee in retaliation for maintaining a work comp claim. There's also other issues that if the injured worker is part of a union, there may be union protections that can be looked at. So these are all things that need to be analyzed if the injured worker doesn't return back to the workplace in either of these scenarios. The first scenario being during the healing or treatment phase. The second scenario is after reaching maximum medical improvement, and then they're not brought back into the employment. There are a few things that else to talk about. Those are really the highlights of the returning back to work issues that injured workers face. The other thing that sometimes occurs is when the injured worker is really motivated and they enjoy their employment, and the employer says, if you have these restrictions, we can't bring you back with restrictions. For example, nurses, if they're interacting or dealing with patients, they can't have any workplace restrictions, or hospitals won't bring them back for the obvious reasons of potential liability or further injury to either the patient or to the injured worker, nurse who returns back to work. So the injured worker sometimes will feel compelled to go to their authorized treating doctor to request the doctor lift any return to work limitations or restrictions that have been assigned. And that is a very tough position to put your authorized treating physician for the obvious reason, but it is something that the injured worker and his doctor, her doctor, have to work out. As the lawyer, I really can't advise on how to deal with that. It's not my body that was injured. I just know how the law operates, and I wouldn't dare advise a client to go against a doctor's wishes unless that's the doctor's orders just don't seem to be logical or applicable to the injured worker situation. But it's, as with all of these workers' compensation cases, every case is fact specific. Please don't compare your case with someone else's. Seek the advice of an experienced workers' comp lawyer to talk about these things, and we'd be glad to talk about any of these return to work issues with anyone who has questions. Alabama workers' comp claims. Again, thank you for spending a few minutes with us. I'm Bernard Nomberg, Nomberg Law Firm in downtown Birmingham. Our phone number is 205-930-6900. We can be found, we have a website, nomberglaw.com. We also have a Facebook page and a Twitter feed. And please give us a call, and if you have any questions or concerns. Hope you have a good rest of your Tuesday and a good week, and we'll see you next week.